Well, good morning, everyone, and welcome to our town hall. My name is Kathy Smith, and I am honored to be Maryland's Assistant Secretary of State. I provide executive oversight of the Charities and Legal Services Division. Today's town hall will provide an overview of the Notary Handbook, the laws and regulations. Before we begin, I'm delighted to introduce you to Maryland's Secretary of State, Susan Lee. Secretary Lee? Secretary Lee, I'm happy to introduce you. One more time. Perhaps I was mistaken. I thought she was on.
Certainly not you. You want to talk to me? Call me at home. Me and Flynn
Flynn and I are out of here. Louis, this is an emergency.
correcting his grammar. Wow. His very first accent.
Secretary Lee?
What's this about?
What the heck?
Well, we'll begin, and if she is able to join us, we'll be happy to have her do so at that time. So as indicated in the email notification about today's town hall, this town hall will be recorded, and the link for the recording will be found on the Secretary of State's website under the Notary tab. By choosing to participate in today's town hall, you are consenting to the recording. Please know that is true for all of our town halls. The presentation is provided for
Would
informational
you call him
purposes
just
only,
a dog in front
not
of your
intended to
grandkids?
be legal advice. With me today is our Division Administrator, Mike Schlein, and he will provide some detailed information in a few minutes. But also, let me let you know that the platform restricts attendance to 500. I'm not sure that we'll hit that threshold today. We often have, but we'll see if we do. And in response to some emails that are received, this town hall is not required, and it is not a replacement for the course of study or a substitute for that course of study that was required by the October 2021 law. The town hall is an outreach on my part to educate the Maryland notaries public and those who are interested. Time is reserved at the end for any questions that folks may have. But I'm going to ask you, please refrain. Do not put any answers to questions in the chat box. Put your questions in the chat box. That's great. But if there's a question that's posed and put in the chat box, we ask that you do not answer those questions. Sometimes folks have inadvertently provided the wrong information. So if there's an answer to something, a question placed in the chat box, that will be addressed by our staff at the conclusion of this town hall. If you have questions about TIPIC, that is the Title Insurance Producers and Contract Independent Contractors, please refer them to the Maryland Insurance Administration. TIPIC falls under the scope of their authority, not under the scope of the Office of the Secretary of State. You might also want to review or take a look at the recording that we have on our website from the February 21st town hall that we did with the Maryland Insurance Administration and our office, specifically on notaries and TIPIC. They may be able to provide some information as well. So our notaries will announce questions at the end. Please feel free to place any questions you have in the chat box. Remember, a recording of today's town hall will be posted on the SOS website under the Notary tab. And once more, the content and presentation is for informational purposes only. It is not intended to be legal advice. I believe Secretary Lee has joined us and is really excited to welcome you to this town hall. So Secretary Lee.
Yeah. Hi, everyone. Maryland Secretary Susan
There
Lee.
you are.
So wonderful to see everybody.
Can't hear you, Secretary.
Oh, okay. Let me see if this. Let's see if it's. Can you hear me now?
Not yet.
Okay. Yeah. Yes or no?
Okay.
Yes.
Sounds like
Okay. Sorry about that, everybody. Technical problems all the time. Hello, I'm Maryland Secretary Susan Lee, and I'd like to thank and welcome everyone for participating in this important town hall. I also like to thank my Assistant Secretary for Charities and Legal Services, Kathleen Smith, and Division Administrator Michael Schling for doing this and hosting this, and also presenting their important information on not only how to become a notary, but also if you're already a notary, to become compliant with our regulations and requirements, and any latest developments that are present now in the notary field. We want to apprise you of all the information and resources that you need to succeed and be the best in this growing field. Again, I thank you for your participation and my very best to all, and good luck.
All right. Of course.
appreciate that. So without further ado, I'm delighted to introduce you to our Division Administrator, Michael Schlein, who's going to take it from here. Mike? I might mention that while we're waiting for Mike to step on, that you're welcome to keep your cameras on if you like, but please mute your microphones. All right, Mike, it's all up to you.
Thanks, Kathy. Good morning, everybody. Good to see so many folks on here this morning. Today, we're going to cover a whole wide range of topics. The Notary Handbook, law and regs, an overview of what you're going to find in those, and cover lots of items today: how to apply, how to renew, guidance regarding the scope of duties and responsibilities associated with performing notarial acts, responsibility to review and understand the content of the handbook. So again, just an overview of all the different stuff you're going to find in the handbook and the law and the regs. Lots of topics to cover today, so we're going to try to move through all these in a timely manner. We're going to go right on down this list here: applying, enforcement, general powers, authority and jurisdiction, identification of a person appearing before the notary's official stamp, also commonly referred to as a notary seal, record keeping requirements, certificates, how to perform different acts, electronic and remote notarizations, charges and fees, and generally what's public information about a notary. So we're going to run through all these topics today. So first, what is a notary public? A notary is an officer of the state of Maryland. Constitutional amendment in 1964 allows a notary public to hold another public office, unlike other state officers. The notary public is held to the high standards of trust as other appointed and elected state officials. And a notary is responsible for reading and understanding the law. They're Title 18 of the State Government Article of the Annotated Code, Maryland, as well as other guidance issued by the Secretary of State, whether that the handbook or the regulations, which are really guidance. They're regulations. You have the law, you have the regulations, and then you have the guidance in the handbook and different information on our website about different topics as well. Notaries are civil officers, so an officer of the state of Maryland. It's an important distinction to think about when you're notarizing, regardless of whether you're doing it for work or just because you're a notary. When you're acting as a notary public, you're acting as an officer of the state of Maryland, not in any other capacity. And there's a legal responsibility to perform notarial acts in compliance with the notary law and the regs. And notaries should not advertise under a trade name. You as a notary are commissioned with your name, right? I'm Michael Schlein. If I'm a notary, I'm commissioned as Michael Schlein, not something else entirely different. So my notary seal will need to say my name, and we're going to talk about everything that needs to be on a seal here a little later on. Notary may exercise all functions of the office of the notary public in any county or city in Maryland, regardless of where the notary is commissioned. So examples, say I'm commissioned in Anne Arundel County, but I'm on vacation down in Ocean City and I need to notarize something. Can I notarize it? Absolutely, I can notarize it. I can notarize anywhere within the state of Maryland. So the key there is being physically located in the state at the time of the Notarial Act. And also a notary may only perform notarial acts under the authority of their Maryland commission while physically located in Maryland. So I'm a Maryland notary public. I have to be standing in Maryland. Again, regardless of where I'm commissioned. If I'm commissioned in Anne Arundel County, I can notarize all the way out from Garrett County down to Worcester County and St. Mary's County, all the way on up to Cecil County and everywhere in between, as long as I'm standing in the state of Maryland at the time of the Notarial Act. Other thing people often ask about, well, what if I'm a notary for another state as well? That's great. When you're in that state, you use that notary commission. When you're in Maryland, you use your notary commission. When you're in Maryland, you follow the Maryland notary laws and requirements using your Maryland seal. If you're in another state and you happen to be a notary there as well, you're using their notary seal and following their laws. So Maryland notary is authorized to act in Maryland only. So who may perform notarial acts? So the significant changes happened in the law October 1st, 2020. Changed a lot of different things, added a lot of information to the law that may not have previously been there. One of the things it did was it created something called a notarial officer, and those folks are authorized to perform remote notarial acts. So that includes a notary public, judge, clerk, or deputy clerk, magistrate, those that are appointed courts of the state of Maryland. So we're really focusing on notaries public out of this section, and those that get commissioned through our office are notaries public. The signature and title of an individual performing a notarial act in the state of Maryland are evidence that the signature is genuine. An individual is commissioned notary public in good standing. And the signature and title of the notary officer listed above conclusively establish the authority of the notarial officer to perform a notarial act. And a judge of the court or a magistrate appointed by the court may not charge a fee to perform a notarial act. The notary public can charge a fee, but not all notarial officers. So thinking of notary publics, how do you apply and renew and get commissioned and all that good stuff that comes with becoming a notary and staying a notary? So basic qualifications of the law, you must be, to be appointed as a notary public, an individual must be at least 18 years old, of good moral character and integrity. They must be a resident of the state or employed in the state or have a practice in the state. So people commonly refer to that as live or work in Maryland, but the law is specific, a resident of the state or employed or have a practice in the state. If living in the state, you're appointed by the senator representing the district in which you live. If you live outside the state, you must be a resident of a state that allows Maryland residents working in that state to serve as notaries public in that state. So effective October 1st, 2021, new applicants must also complete a course of study and pass an exam to become a notary. You're going to do that before you apply to become a notary. And renewing applicants must pass the course of study in order to renew. So you're going to take that during your renewal window in order to renew. So you're going to pass your course of study and exam, submit a new application to be a notary after that happens. Part of your application is actually the certificate that say you took the course of study and passed the exam. And if you're renewing, you're going to take that course of study before you submit your renewal application, because part of your application is going to be the certificate that says you took that course of study. How do we apply to become a notary? You apply online. All applications are online. Applicants, you want to have everything ready before you apply, because if you're inactive for more than 30 consecutive minutes, you will get logged out and all that information is lost. So when you're going online to renew or apply, make sure you have the information you need in advance before you start that application, so that you don't, avoid losing any information and save yourself some time, right? Because nobody wants to start it and then have to do it all over again. So you must read and understand the law and the regulations before applying. And a lot of times when somebody applies to be a notary, the law is written in a way that your state senator can make a determination on your notary application and decide whether or not to recommend you be a notary. But state senators are allowed to opt out of that process. Most of them have. There are some state senators that still review notary applications. But if your state senator has opted out, they've delegated that authority to us to make a determination on your notary application. Usually, if you're a new applicant and the Secretary of State has been delegated the authority, we're talking about a 2 to 5 days tops, not usually more than a week. If a state senator does it, we say usually a range of 1 to 6 weeks. But if you haven't heard anything in 4 weeks, you might want to check back in with us and just make sure it's still there awaiting approval. So it's not usually longer than that. The applications, they're gonna go. We have references for new applications. And could you please mute your microphone there, please? Thank you. The references responding tend to be the one thing that holds thing up if it gets held up at all. If it's an opt-out application, so the Secretary of State approves the application, your reference is going to get an email after we've reviewed your application, determine it to be complete, not missing any information. Next thing that happens is your reference gets an email from us, and at least one of those references need to respond positively in order for that application to move forward. So be proactive, though. Check with us if you don't hear anything. Don't assume a determination of the status of the application has or hasn't been made. Never assume. If I've learned anything, never assume it's being done. If you haven't heard anything within these time frames, you check with us in the notary division and make sure the last thing we want to happen is you missed out on that approval and possibly have to do it again. And we'll talk about that here in a few. So again, have everything ready before you apply. A government photo identification that verifies your home address is one of the things you need. So you're going to have an electronic image of, most oftentimes your driver's license or your non-driver state issued identification card, and it verifies your home address. Why is that? When we get your notary application, we're going to check that application against that ID and make sure the names match, date of birth, address, the person is who they say they are, who they are applying to be a notary as. We want to make sure that is the same person. If the current address does not match the address provided, we're going to be asking for that MVA, change of address card, the Motor Vehicle Administration change of address card. So if you have a driver's license and the address on that license is no longer your current address, make sure you attach your MVA change of address card to that application as well, so we can verify that the address on your application is in fact your current address, because it would match. If it doesn't match your ID, your change of address card. So you're also going to provide contact information for references. I mentioned earlier that this tends to be one thing that sometimes slows down in getting approved. Make sure you give us good contact information for those references, and as always, if picking somebody to be a reference, you should let them know, hey, be on the lookout. You might get an email or a phone call or some mail or something like that from somebody about my notary commission, and please respond. Let people know, let your reference know that they're going to get something from us or from your state senator. And that failure to respond if a reference does not respond, it can prevent your approval becoming a notary. So make sure you give us good reference info. You're also going to need the legislative district in Maryland where you reside. Check the legislative district at mdelect.net. You can type in your address, and it'll tell you who all your elected officials are, including your state senator. That's legislative district and state senator are going to be put on your notary application. So when you go to that website, you can enter, like I said, enter your address on the left-hand side of the page, and all that information will come up. But don't give us your the names of your House of Delegates, folks from your legislative district. We don't need to know who your state your U.S. senator is or your U.S. congressperson is. We need to know who your state senator is. The fee to apply is $9. It's due at the time of application. There's a $2 service fee that's also attached here, so essentially $11. You can pay by credit card, electronic check, or PayPal. So in general, the process here, a new application process, we're going to get the online application, and the Secretary of State's going to receive it that next business day. So if you did it today, we'll have it tomorrow morning. Application reviewed for completion and to ensure you provided a valid home address. We're going to check background, see if there's any criminal convictions or judgments. If that criminal record, if you have one, hopefully you don't, but if you do, disclose it, right? Make sure you disclose it. Be honest on that application. If the answer to have you ever been convicted of a crime is yes, select yes, and you'll be allowed to explain what that conviction was or any other information you want us to know on that notary application about that conviction. So if the answer is yes, be sure to say yes. Same with civil judgments, or if a commission's ever been revoked previously in Maryland or another state, be sure to disclose it. Be honest about the application.
That's such an important thing to drill home, because to say no if the answer is yes is falsifying a document, right? So you need to have the right answer. We'll deal with whatever. You have an opportunity to explain. In fact, you're asked to explain circumstances. So please just make sure you answer honestly and correctly so that we can help you help you.
Right, exactly. And it's a, good moral character, right? That is that's the name of the game. One of the qualifications to become a notary. So be honest on that application, show good moral character, be honest, help us help you, like Kathy said. If the senator delegates authority to us, we're going to contact your references. And if the senator retains that approval authority, they'll probably contact your references, at least one or all. And determination that's made by a state senator or the Secretary of State, depending on who's reviewing that application. And if that application's approved, you're going to get an email from us that tells you you're approved and tells you to go to the clerk of the circuit court to appear in the county in which you were commissioned. So if you live in Maryland, you're going to get commissioned in the county in which you reside. And if you are not a Maryland resident but work in the state, you're going to get commissioned. Pay attention to what county in which you are commissioned. That's the clerk of the court in which you want to go to get sworn in. Read those instructions in that email, though, to obtain that commission from the clerk of the court. Read the instructions. It tells you where to go. It tells you how long you have. Gives you their contact information in case you need to call them to check on anything. But have those instructions handy. They're going to come to you in the form of an email. Make sure you read all those instructions. And also, don't kind of open it, close it, put it to the side, and forget about it. You don't want to forget about it. Why don't we want to forget about it? Why do we want to make sure we read those instructions? This next page here, you have to appear before the clerk of the circuit court to take that oath of office and receive that commission within 30 days of the date of the notification. So the date that we send that email, you have 30 days from that date to get sworn in and receive that commission. If you do not appear within those 30 days, that commission is revoked, which means you would have to reapply and start all over. You don't want to do that. We don't want to make you do that. So make sure you get sworn in within the 30 days so that doesn't have to happen. And again, that's 30 days from the date of the email that we send. Check your inbox, check your spam folder. If you've submitted a new application or a renewal application, make sure you're checking your email inbox and spam folder for it. And we talked earlier about new application process and how long it could take. Don't let it run more than a month after you apply before you check in. And the reason we say that is if you only get 30 days to get sworn in and you wait more than a month to check in on your application, if you haven't seen anything, it may have already been approved and that 30 days may have come and gone. So check in before a month. Don't wait longer than that to check the status of your application. All too often what we see happening is, folks apply and they just kind of go about living life and forget about it. And, 3, 4, 5, 6 months later, 12 months later, folks are calling us saying, oh my goodness, what happened? And, that email was sent Whether or not it was seen is not so relevant. Make sure you're checking your email. If you don't see it, you check in with us so that you don't have to reapply, so that you get your commission the first time after you're approved, and you don't have to pay us again to submit another application. Again, we don't like that. Nobody likes that. And no notary likes that when that happens. And those aren't fun calls for us either. So if we can prevent them, we want to prevent them. Get there, take that oath within 30 days after you're notified. And if you don't see that notification, check in with us. If you're a renewal application, don't let it run. You should hear from us within a week, tops, about whether or not that renewal's been approved. So make sure you're checking in with us and being proactive. Don't wait till it's too late, and wait too long. We get folks all the time that I forgot about it, or I changed jobs. I didn't think I'd have to do it anymore, and I just didn't go get it. Well, make sure you go get it. If it's already been paid for and you've been approved, go get that commission. Whether or not you end up using it, hey, but go get that commission just in case you need to become a notary again. That way you don't have to reapply. Clerk of the Circuit Court provides notary commission after you're sworn in. So you're going to go to the clerk, you're going to take an oath of office, you're going to receive that commission from the clerk of the court. At that point, you're officially a notary public, and you're going to owe the court $11 to commission you. So that's a separate $11 from that application fee that you're going to pay us.
Yeah, I was just going to say the same thing, Mike. That's so easy for folks to get confused about. There are separate and distinct $11 charges. So,
Yep.
Yeah.
And so complete that renewal application online for the renewal process. Same place you go to apply. It's the same place you go to renew. And a lot of this is going to look very familiar because the renewal application is tremendously similar to the new application. The only real difference between news and renewals is new applicants have to provide their references, and the new applicant also has to pass the exam, not just take the course of study. That's really the only main differences between a new and renewing application. And so you're going to submit your renewal, and just like a new application, we're going to get it the next business day. So if you did the renewal application today, we're going to see it tomorrow morning, and we're going to begin reviewing that application. And we're going to also check background, same thing. If the answer is yes to criminal conviction, civil judgment, say yes and explain it. If you check yes, you get a box where you can type in what it was you were convicted of and any other information you want us to know. Again, I can't reiterate it enough. Just be honest on that part. The easiest way to get denied is to check no when the answer should be yes. So if the answer is yes, just check yes and explain it. And that way you at least have a chance of getting approved. If you are approved, you're going to get an email from our office telling you that it's been approved and that you need to go to the clerk of the circuit court in the county in which you're commissioned. And again, read the attachment. It has the instructions, or read the email, I should say, and the attachment. It has the instructions. It'll tell you what to do. Same basic process as a new applicant. You get approved. You need to get there within 30 days. Otherwise, that commission's revoked and you have to reapply. Don't let that happen. Get to the clerk of the circuit court within 30 days of approval. And again, if you don't hear anything, check in with us. Be proactive. We'd much rather you check up front on the status to see if you've been approved yet, then wait till it's too late and check on it then. So check in with us. Be proactive. Don't just sit and wait and assume it's going to happen. Never assume. That's a good rule for anything in life, right? But don't assume. Be on the lookout for that email. If you don't see that email, check with us. Maybe something's wrong. Maybe we were trying to get a hold of you for something and it was missed, right? Maybe it was approved and it was missed. Either way, check in with us. Don't wait too long. You only get 30 days after that email is sent to get sworn in. If you don't see that email, again, if you've submitted a renewal application, check with us within 1 week. If you don't hear from us in a week about being approved or denied, call us, email us, check with us.
Mike, these are such great points, and bears repeating again that there are two separate fees. Well, the Secretary of State has a $9 application fee, there's a $2 service fee, and then separate and aside from that is the $11 fee that the clerk of the court charges. They just happen to be the same number, but they're separate and distinct fees. That 30-day, going to the clerk's office and getting sworn in with 30 days is really imperative. You don't do that, you have to apply all over again. And that's not something to read you, that's the law. So, help us help you, because we want to help you succeed. But you need to cooperate in the first part of making sure that you show up and get sworn in, and then you can be good to go.
Yep, and this page reiterates a lot of that. We already talked about it for new applicants. Get there within 30 days. You're gonna have a fee you pay to the clerk to get commission. Don't fail to appear within those 30 days because that commission gets revoked. You have to reapply. Like I said, it's the law. Nobody has fun doing it, so don't make us make you do that. Get sworn in within those 30 days. Clerk of the Circuit Court provides notary to commission after they're sworn in, just like a new applicant. Every time you renew, you go to the clerk of the court and you get your next commission. You take your oath of office every time you get commissioned. Some folks go, oh, I got sworn in the first time. I didn't know I had to go back. Yep, you do. If you don't go take the oath of office for your next commission, you're not a notary anymore. You always have to go to the clerk of the circuit court to take the oath of office for that next notary commission and receive that next notary commission. If you're changing your name and address, so changing your name, you're going to notify us of the name change. You go right to that online application page and you click on update your notary information. You have a couple options when it comes to changing your name. You can just let us know your name's changed and finish out your commission under the name under which you were commissioned. So you can just keep your old name for the duration of that commission. Or you change your name, you can get resworn in under the new name. So if you want to use your new name when you notarize, you will let us know that on the online form. And after we process that name change, if you want to notarize under the new name, we're going to issue a commission to the clerk of the circuit court, and you're going to go there and take the oath of office under your new name. So either is fine. You can continue notarizing under the name under which you originally commissioned for the rest of that term, or you can finish that term under your new name. If you do, it'll require you to go to the clerk and get sworn in again. $5 to us for the reissuing of the commission. And if you get sworn at the clerk again, you'll have to pay them the $11 again to take the oath of office. So it's really up to you. The key there is consistency, though. If you want to keep your name until you expire, when you expire and you renew your commission, that's when you'll start using your new name. So you can wait till then if you like. Of course, if you change your name in the middle of your term, you need to go get a new notary seal as well to reflect the new name under which you're commissioned after you're sworn in under that name. But the key is consistency. If you choose to finish out your term under your old name, great, keep your seal, finish out your term under your old name. When you renew, then you'll change your name and you'll need your new seal at that point. You'll go get sworn in. So, and you'll let us know that when you're filling out the name change there in the update your information section. If you want a new commission with that new name on it, you'll be prompted to pay the $5 fee for that. And you'll have to go get sworn in. For changing the address, notify us within 30 days of the change of the address. Same place, go to update your information on that notary form online, and you're going to let us know of your new address or phone number or anything else for that matter that you need to update. If you change your address, you don't have to go get sworn in again. Even if you end up moving to a different county, you don't have to go get sworn in again. And on that note, say I got commissioned in Arundel County and I moved to Baltimore City. My notary seal says Michael Schlein, Notary Public, Anne Arundel County. Even if I move to Baltimore City, it's going to continue to say Michael Schlein, Notary Public, Anne Arundel County, until the next time you renew your commission, and at that time you'll get sworn in the new county. So a change of address does not require you to take an oath of office or change the name, the county name on your seal. You're going to finish out that 4-year term with what's the county in which you were already commissioned, right? That notary seal is going to have the county in which you're commissioned. So if I got sworn in Anne Arundel County, Michael Schlein, Notary Public, Anne Arundel County, because that's where I was sworn in, I don't have to get sworn in again if I change my address. So I'm going to keep that Anne Arundel County seal until the next time I get sworn in. And if I get sworn in Anne Arundel County in those 4 years, great, I keep that seal. And if I've moved I'll get my new seal at that time after taking the oath of office in the new county.
Mike, it might be worth mentioning that while updating your street address is important, it's also important to update your email address. If you change your email address, to notify our office as well, because we send communications out via email.
Yep, and then right on down this page here, providing contact information that's current, right? Name, home address, home phone, cell phone, email address, business phone, even business address, right? Keep your contact information current with our office. Important. Enforcement. So we commission you as a notary. It's a notary commission. You're an officer of the state. Can that commission get revoked? Yep. Yes, it can. You can be removed from the office of notary public. The Secretary of State, they may deny, refuse to renew, revoke, suspend, or impose conditions on a commission as a notary for an act or omission demonstrating a lack of honesty, integrity, competence, or reliability to act as a notary. For any of these reasons, failure to comply with the title or the regs, fraudulent, dishonest, deceitful misstatement or omission in the application for a commission or for a renewing commission, conviction of a felony or crime involving fraud, dishonesty, and deceit, admission of liability in a legal proceeding or disciplinary action based on fraud, dishonesty, and deceit, failure to discharge any duty required of a notary, whether it's imposed by any federal or state law or regulations adopted by the Secretary of State, use of false or misleading advertising or representation by a notary representing the law. The notary has a duty, right, or privilege that the notary does not have, and denial or refusal to renew, revocation, suspension, or conditions of the notary commission by another state. So many reasons that a notary could find themselves in hot water. Don't let you be one of these reasons. Fill out that application, be honest on that application. When you're acting as a notary, know what you're supposed to do. Pay attention in that course of study, right? Pay attention in that course of study. It's going to tell you what you need to do as a notary. And make sure you follow those laws and regulations and the information in that notary handbook. You know, we're going to talk about the different things as we go later on here, but notary seal, make sure it's right. Journal requirements, make sure you're doing your record keeping, that's required. Make sure you know how to properly notarize something. And we're going to talk about all that here soon. So if the Secretary of State decides it wants to revoke your notary commission, you have the ability to have a hearing. You can request that hearing upon notification that our office intends to remove you. That notice and hearing satisfied if we mail that letter to your last known address. So make sure your address information is current, right? And that hearing is an informal hearing. It is not a formal hearing. It is not a courtroom. We are not before a judge. It is your opportunity to explain to the agency why the agency should reconsider. It is an informal hearing. And any action taken against the notary, if we decide to revoke a notary or something like that, does not preclude a person from seeking and obtaining any other criminal or civil remedy. So the process of us revoking a notary commission is separate from the process that may play out in any criminal or civil proceeding related to anything that was done. So if a notary public is convicted of a felony or a crime involving fraud, dishonesty, or deceit, that notary shall report the conviction to the office of the Secretary of State within 10 days of the conviction or within 10 days after their release from incarceration, whichever is later. Failure to properly report that conviction may result in an enforcement action against the notary public under the Code of Maryland regulations. So if a document's notarized incorrectly, the validity of the Notarial Act under the law does not prevent an aggrieved person from seeking to invalidate the record or transaction that is subject to the Notarial Act under another law or other remedies allowed under federal or state law. So what does this really mean? It means that if the notary did something wrong, somebody could take the notary to court, so to speak, to try to get that overturned. But also that because the notary did something wrong, it doesn't necessarily invalidate the document in of itself, right? If a notary forgets to fix their seal or affixes a seal that's an incorrect seal. It doesn't in and of itself invalidate a notarial act by the notarial officer. But folks could try to push that in the judicial system if they so chose. So what are we talking about here? Powers and authority of a notary. A notarial officer has the following general powers. You can take an acknowledgement on a record. You can verification on oath or affirmation of a statement, witness or attest to a signature, certify or attest a copy of a record of an item that was copied, certify a tangible copy of an electronic record, and protest of negotiable instruments. So these are the general powers. We're going to talk about all those in a little more detail here soon. Authority and jurisdiction of the notary public that we talked about earlier. You can notarize anywhere in the state of Maryland, regardless in which jurisdiction you were commissioned. You're commissioned in Baltimore City, you can notarize anywhere in Maryland, right? Whether you're in Baltimore City, Baltimore County, Ocean City, Frostburg, wherever, you fill in the blank. If you're standing in Maryland, you can notarize. The Maryland notary is not authorized to act as a notary in another state or the District of Columbia. So you cannot take your Maryland notary seal, drive across state lines or into DC and notarize using that Maryland notary seal. You have to be standing in Maryland at the time you notarize using your Maryland notary seal. Can physically present in the state of Maryland. A notary of another state may not act as a notary in the state of Maryland unless they also hold a Maryland commission, in which case use your Maryland notary seal, right? Use your Maryland notary commission as your authority if you're notarizing in Maryland. And
that's a really, really, really good point, because Maryland, as is true for many states, does not have reciprocity with any other state on notarial act. And so remember, being a notary public is a public official in the state of Maryland, public office. You have to be commissioned. Same is true if you want to notarize in Pennsylvania, Delaware, West Virginia, the District of Columbia, wherever else, any other state, need to be commissioned in that state or that district.
right. And you know, the thing to mention here too, the last bullet point there about it doesn't really matter where the document is coming from or going to. What matters is that the notary is standing in the state of Maryland at that time, right? The notary needs to be in Maryland. That document maybe the person's from a home, maybe they're from California, maybe they're on vacation in Baltimore, and something happened and needs to be notarized. They go to a Maryland notary. You're in Baltimore, it can be notarized, right? You're in Maryland, it can be notarized. It doesn't matter where the person's from. It doesn't matter where the document is from or going to. What matters is that the notary public is in the state of Maryland when they're notarizing that document. That's what's important. Conflict of interest and restrictions. So a notarial officer may perform a notarial act authorized by the laws of the state. However, a notarial officer may not perform a notarial act with respect to a record to which that notary or their spouse is a party, or in which the notarial officer or their spouse has a direct beneficial interest. So don't notarize for something in which you're personally involved, right? Can't notarize your own signature. Can't notarize your spouse's signature. Those are absolute no-nos. If you're involved in that transaction that requires a notarial act, don't notarize it, right? It's a conflict of interest. Notary is supposed to be kind of that independent third party, right? Witness to a transaction, identifying folks, making sure they are who they say they are. And, you know, you can't be that disinterested third party if you're a first or second party to that agreement, right? So if you're involved in it, don't notarize it. While law only prevents a notarial officer from performing a notarial act in which the notarial officer or their spouse has a direct beneficial interest, we recommend a notarial officer refrain from performing the following acts. So for any members of the immediate family, even if you're not under a legal duty to refrain. So again, you're required to refrain if it's yourself or your spouse. But the reality is, don't notarize for your family. You know, you see very, very interesting things happen, but right, everything's good. Oh, it's my family, we're great. Everything's good till it's not, right? And I former life dealing with notary complaints and investigating them, I can tell you firsthand, many of those complaints about notarizations are about notaries that notarized for family members, right? money and property. Everything's great till it's not. So stay away from notarizing for family. Find somebody that's truly a disinterested third party, even if you're not under the legal duty to refrain. Don't do it for your immediate family members. And really any other notary a matter in which there's personal involvement, even if there's indirect involvement where there's no beneficial interest, just stay away from it. Stay away from it. There's about 90,000 notaries in Maryland. You can find another notary to do it and do it correctly, right? Find a notary that's not involved. You will thank me later. Notary public may perform notarial act for any person other than the notary or spouse to any instrument which involves corporation of which the notary is an employee and to which the notary public is not a party. So what's that mean? You work for a company, something needs to be notarized. Say you work at a bank and maybe there's some type of bank document, somebody's opening an account or getting a loan or something like that, and the document requires a notarial act. You, the employee of that bank, could notarize that document even though you work for that bank. That's essentially what that last bullet point means. So other restrictions: can't draft legal advice just because your commission isn't, can't draft legal records or give legal advice. I mean, just because your commission is a notary. If you're an attorney, if you're a licensed attorney, right, you're licensed by the bar to practice law in the state, you can do that. But not just because you're a notary. If you're a notary public, you can't draft legal records or give legal advice or otherwise practice law. You need to be an attorney to do those things. You can be an attorney and a notary. Great. You're an attorney. You can do those things, right? You can't act as an immigration consultant or expert on immigration matters just because you're a notary. A notary commission does not empower you to do that. Represent a person in a judicial or administrative proceeding relating to immigration to the United States citizenship, or other related matters. Again, just because you're a notary doesn't mean you get to do that. Or receive compensation for performing any of the above matters. If you're not licensed to practice law, you should not be practicing law. Notary cannot engage in false or deceptive advertising, can't use the term Notarial or Notarial Publico unless the notary is an attorney licensed to practice law in Maryland. And you can't represent that the notary may assist persons in drafting legal records or give legal advice or otherwise practice law unless a notary is a licensed attorney in the state of Maryland. If a notary who is not an attorney licensed to practice law in the state of Maryland advertising or represents that the notary offers notarial services, whether that's an oral offer or in a record somewhere, whether it's broadcast media, print, internet, the notary shall include a statement that says, I am not an attorney licensed to practice law in the state. I am not allowed to draft legal records, give advice, et cetera, right? You don't want to make somebody believe that you can do that unless you can. You can't draft legal records, can't give advice on legal matters, including immigration, or charge a fee for those activities. So if you're advertising and writing you're a notary, or you're advertising to people you're a notary, even if it's spoken word, you need to have that disclosure provided and made for those people so that they know you're a notary, you're not an attorney. Again, if you're an attorney, practice law all day long, right? But if you're not an attorney and you're a notary, you cannot do it. Identification of persons appearing before the notary, competence. Every time you notarize something, the person's required to appear before you. And we're going to talk about remote notarizations later. There's a little twist on that, right? But thinking of the traditional method at the moment, somebody has to come before you. We're in the same room at the same time, at the same place. Personal appearance before the notary. That person must appear every time you're going to notarize for them. Doesn't matter how well you know them or think you know them or know their handwriting. Personal appearance is required every time you're notarizing a document for someone. There is a law that requires that allows something called remote notarial acts using communication technology, commonly referred to as a remote notarial act, and that allows somebody to be in a different place than the notary and appear using certain communication technology that's allowed under the laws for notarizing documents. So there are many requirements for performing remote notarial acts. that are explained in the handbook. We're going to talk about some of it as an overview later. But bottom line, personal appearance, whether that's in person for your traditional remote notarial act or personal appearance using communication technology that's authorized under the law and appearing before a notary that way. Identification. Notary must satisfactorily identify that signer, right? Every person requesting a notarial act each and every time to be identified. Have to identify them prior to performing the notarial act. There are 3 methods to identify somebody. Personal knowledge of the identity of a person appearing before the notary is sufficient. You know them. You know them, right? You don't like know them in passing or kind of know them or know them because you see them come through your store every now and then. Personal knowledge of the identity of the person appearing before you. You know who they are satisfactorily and beyond a reasonable doubt. Satisfactory evidence could also include government issued identification. So by means of what? Government issued identification, whether it's a passport or driver's license, consular ID, government issued non-driver ID card. Those are your main ones you're going to see. You're almost always only ever going to see a driver's license, a government issued non-driver ID card, or a passport. Those are kind of the big 3. Maybe you get a military ID in there every now and then, right? But those are the big 3. Other government ID you could take another form of government ID, but that other form of government ID would need to contain the person's signature and their photo and be satisfactory to the notary. So what does that last phrase mean? It's a good phrase, because if you're not familiar with that form of ID, you don't have to accept it, right? It has to be satisfactory to you. If you don't know what that is, probably shouldn't take it, right? Just because somebody says it is doesn't make it so. And, folks will tell you anything, right? You ever go on the internet? Folks will tell you anything. So just because somebody says something, it doesn't make it so. Stick with the ones you know. If you're familiar with that other form of ID that isn't included in passport, driver's license, consular ID, or government issued non-driver ID card, if you're familiar with them and you can take it and it meets that requirement of a signature and a photo, great. However, if you're not, don't use that form of ID, right? Because you need to make sure they are who they say they are and know that they are who they say they are. The third version of identifying somebody, or the third method, I should say, is credible witness. So evidence by means of verification on oath or affirmation of a credible witness who is personally appearing before the notary and known to the notary or through identification to the notary that can identify that party that needs to be notarized. So somebody comes before you and you can identify them through someone else that knows them, or preferably through someone else that you know that knows them. But you also, if you're using that credible third-party witness, you still need to get all the information, the identifying information, into your journal from the person that's being identified as the credible witness. But also you want to get the person who is the credible witness. You want to get their information in your journal as well. Minors, they may have an ID or current passport or valid driver's license. Many minors don't have IDs. So the one way, that's one time in particular where a credible witness may come in handy. Maybe you have a minor that doesn't have an ID, you need to notarize something for them. The other time you may see it is for folks maybe that or are older in age that are no longer driving, and maybe they don't have an ID or something like that. And you may need somebody to satisfactorily identify them as a credible witness. But your main methods of identification should be government issued photo ID or personal knowledge if you know the individual that's requesting the notarial act. Those should be your go-tos whenever possible. Credible witness, again, there are situations where you'll see it, but think about it, right? If I drive to you and request a notarial act and I say I don't have a driver's license or ID card and I drove to you, I got other problems, right? I'm driving without a license. So, there are times when credible witness will make sense. Although it is, again, it's a allowed method of identification. But when in doubt, government issued ID, personal knowledge. Competency and awareness. So unless otherwise prohibited by law, a notary may refuse to perform a notarial act if not satisfied the individual executing the record is competent or has the capacity to execute the record. The notary should interact directly with the person requesting the notarial act. Notarial act should not be performed if the signer does not appear competent or aware of the documents being notarized. The role of the notary is not to quiz the signer. The notary's role is to observe and assess if, in the notary's judgment, the signer is impaired and lacks the capacity to execute the document. So the key here is you're communicating directly with the person requesting the notarial act, not anybody else. And that's a very good indicator as to competency and awareness, right? You can talk to somebody and you get a pretty good beat on whether or not they know what's going on relatively quickly in a normal conversation. Say, for an example, little Johnny comes in with his grandparent and is telling you that something needs to be notarized, and pushing the grandparent to do it. Grandparent seems unaware, unwilling. At that point, we're not talking to little Johnny anymore, right? We're talking to the grandparent. Hey, what's going on? Need this notarized? What's going on? You have that basic interaction with that individual, and that'll tell you a lot. That person, little Johnny shouldn't be pushing, right? That's not their notarial act to have done. And they should not have a problem with you interacting directly with the person who needs the notarial act performed.
That's a great point, Mike. It should be a huge red flag if someone accompanying the signer answers all the questions and interferes with the signer responding directly.
And that can be a tough situation sometimes. Sometimes those get pretty heated or testy. Hold your ground though. If it gets heated or testy, then that's another red flag, right? That maybe something's going on here that's maybe not the most savory. You're gonna notarize for the person that needs the notarial act done, not anybody else there. And duress as well, that kind of leads into duress, right? And unless prohibited, a notary may refuse a notarial act if not satisfied that the signer's signature is knowingly and is being affixed knowingly and voluntarily. If the notary determines that the signer is under duress, the notary should refuse to notarize. So you have the authority under the law to refuse notarial act to be performed for competency or duress. Somebody's physically unable to sign. What could happen if a signer that's not impaired or under duress, but physically unable to sign the record? The individual may appear before the notary and direct another individual other than the notary who is concurrently appearing with the individual before the notary to sign the individual's name on the record. So what are the key phrases in there? This is all concurrently occurring. The person that's physically unable to sign it can direct somebody else who's also there at that point in time, but is not the notary, to affix their name. If that happens, you want to get the person who was directed to affix their name as well in your journal, in your record. If an individual is directed to sign the individual's name, the notary shall insert on the record the following words or words of similar import, which is the signature affixed by and the name of the person that wrote it, at direction of, and the name of the person who directed them to sign or affix their name. An individual does not have to designate someone else to sign. If they're physically unable to sign the record, they could do what's referred to as a signature by making a mark. So some type of marking to indicate that they have signed this record. If that happens, maybe make a note in your journal there, right, about the fact that it was signed by Mark rather than a full signature. The notary public's official stamp. So your stamping device is what it's referred to in the law now, but commonly known as a notary seal. It can be an ink stamp or an embosser, or an electronic device that's affixed to electronic records. The notary's official stamp must be able to be copied together with the record to which it is affixed or logically associated. The notary stamping device is a public seal for the purpose of Section 8-607 of the Criminal Law Article. And that section of the Criminal Law Article references counterfeiting a public seal. So notary seal is a public seal. Cannot falsely or corruptly affix it. The official stamp of a notary public shall include the notary's name as it appears on the commission. If I am Michael Schlein, and my name on my commission is Michael Schlein, my notary seal needs to say Michael Schlein. Can't say M. Schlein or Mike Schlein or Mikey Schlein or Mikey S. or whatever. The name on the commission is the name that should appear on that seal. The other things that should appear on the seal are the words Notary Public. The county, or in Baltimore City, if somebody lives in Baltimore City or commissioned in Baltimore City, the county or city of Baltimore in which the notary is commissioned. Important to note, I'll throw this out because we've been asked a few times about it lately. Can't have a seal that says Baltimore City County or Baltimore County City. There's no such place. You're either Baltimore County or you're Baltimore City, right? So your seal needs to say the county in which you're commissioned, or if you're commissioned in Baltimore City, it should say City of Baltimore or Baltimore City. The expiration date of a notary's commission should be on the notary seal unless the expiration date is part of the notarial certificate or affixed to or logically associated with the record being notarized. So everybody that read those first few words before they read the last part probably thought, oh my goodness, my seal doesn't have my expiration. And that's okay, as long as you're properly notarizing documents. Because every notarial certificate example that's in the handbook and in the law has a line for the notary's expiration date, or you could otherwise logically associate it with that record by writing it on there if it's not there. So your notary seal doesn't have to have it as long as it's somewhere else on that record, on that notarial certificate. So a little more information about the notary seal. The notary is responsible for the security of that stamping device. You cannot allow other people to use it. Nobody else can perform a notarial act with your notary seal. You cannot allow them to do that either. Keep it secure, keep it safe. It is your notary stamping device. It has your name on it after all, right? Your name. It is your property and it is your responsibility. If you leave your employer, you take it with you. Did they buy it? Take it with you. It's your notary seal. Don't leave it sitting around. Far too many horror stories of notaries that left the place of employment, thought, I don't need to notarize anymore. And sure enough, a year later, the notary seal showing up on everything at that company, or related to an individual that knew that person at that company that's now using it. Don't put yourself in that spot. Take care of that notary seal. It is your seal and only your seal. If you resign or have your commission revoked, disable that stamping device. Do not allow it to be used, render it unusable. And if your stamping device is lost or stolen, either the notary or the notary's personal representative or guardian should notify the Secretary of State that that has happened. Let us know if that seal is lost or stolen. Let us know as soon as you realize that has happened so that we know it was lost or stolen. In case it does start showing up later, we're aware of that. Record keeping. So the notary's journal, formerly known as the Fair Register of Official Acts. A notary for each and every notarial act, even if it's the same person all the time, must make a journal entry in their journal for each and every one of those notarial acts. For everyone, Mike? Yes, for everyone. But I notarize from all the time. Well, you're going to keep a journal entry for them all the time, every time you do it all the time, right? Always, always, always retain that journal for 10 years after the performance of the last notarial act in it. So always making a journal entry for every notarial act. That journal needs to be kept for 10 years after the performance of the last notarial act that is found in it. For traditional notarial acts, you're going to keep a paper book journal. For electronic notarial acts, you can keep electronic journal. So for your notarial acts of tangible records, so your traditional notarial act on paper, you keep one journal. It chronicles every entry. That tangible journal must be a permanent bound register with numbered pages. For electronic journals, you may have more than one. Why? You may use more than one technology to remotely notarize something. So as part of that remote technology, they probably have a journaling feature on that platform. So if you have if you're doing remote or electronic notarial acts, you may have more than one electronic journal. It must be temper evident and must comply with the requirements in the law. So always making a journal entry And every journal entry should have the following things: the date and time the notarial act was performed, description of the record and the type of notarial act, the full name and address of each individual for whom the notarial act is performed. Needs to identify, or the identity of the individual is based on personal knowledge. Say that. If it's based on satisfactory evidence, describe that satisfactory evidence. And include the date of issuance or expiration date, and if the ID number. If it's something like a driver's license, everybody has a driver's license number on their license, right? And don't answer, meaning this rhetorically here at the moment. How many people actually know their driver's license number? Not a lot. I think I can get through like the first 6, right, numbers, the letter in the first 6 numbers, but it's very, very good and strong evidence that you've satisfactorily identified somebody if you have their information in your register, right? Journaling is an important. You're a public officer, you need to record your acts. But the journal is also a fantastic tool to prove you did everything you were supposed to have done, should there ever be a question that comes up after the fact about a notarial act you performed. So describe the satisfactory evidence: driver's license, Maryland driver's license number, such and such. Maryland non-driver ID card, number such and such. The fee, if any, that was charged by the notary. If there's no fee charged, the record should indicate that there was no fee charged. We're going to talk about fees later, but you should probably break down your fee in your journal, right? If you charged for the notarial act and because you had to travel there, maybe you charged for mileage to perform it, break down what those fees were. How much of that total fee you charged is for the actual act versus how much is for travel or one of these other expenses. But yeah, we're going to talk about that towards the end. Indicate in the statement or indicate that the signature of the act was either in the physical presence of the notary or remotely done. So if you remotely notarize, you need to indicate in your journal that it was a remote notarial act. Make sure you indicate that if your journal is lost or stolen, just like your notary seal, let us know. Tell us as soon as you discover that so that we know, because you're required to have that journal. But if it's lost or stolen, you let us know immediately so that we can make note of that and take account of that should anything ever come up. If that happens, go get a new journal so that you can continue using it to notarize. Journal, always a journal entry. So electronic devices must protect the journal and the audiovisual recordings. We're going to talk about remote notarial acts here a little bit, but you need to, part of remote notarial acts is that a recording of that notarial act is made and is stored. And just like the journal, it needs to be stored for 10 years. If a notary public engages with a third-party repository, there should be a contract, and it shall enable the notary to comply with the retention requirements of the law even after the contract is terminated, or provide that the information will be transferred to the notary public if the contract is terminated. The third-party contract under the is deemed to be an approved repository. We don't have a list of approved repositories for notary journals, but if you have an agreement in place that does this, it is deemed to be an approved repository under the law by the Secretary of State's office. If you resign or you're revoked or suspension of the notary's commission, the notary must still keep that journal, right? 10 years from the time of the last entry in that journal. Inform the Secretary of State where that journal is located. If there was death or an adjudication of incompetency of a current or former notary, that notary's personal representative or guardian would maintain possession of that journal or transmit it to a repository approved by SOS. So in other words, transmit it to a repository with which it has an agreement that will allow it to be maintained and kept in a form that is required under the law. So on the notarial certificates, effective October 1st, 2020, the law requires notarial certificates for each and every notarial act. A certificate has to be affixed to that document, that record. Different type of notarial certificates are required for different types of acts. And the notary needs to know what type of notarial act they're doing. We're going to touch on those here in a few. But each notarial act shall be evidenced by a certificate, and that certificate needs to be executed contemporaneously with the performance of the notarial act. So at the same time and place and occurrence as the notarial act, that certificate needs to be executed. Needs to be signed and dated by the notary. And if the notarial officer is a notary public, sign in the same manner as on file with the clerk. Identify the jurisdiction in which the notarial act is performed. Contain the title of office of the notarial officer. And if the notarial officer is a notary public, indicate the date of expiration, if any, of the notarial officer's commission. So mentioned earlier about the expiration date being on your seal, unless it's somewhere else. Well, if you got a good notarial certificate, it's going to be on the certificate. So it won't have to be on your seal because it'll be on the certificate. By executing the certificate, the notary is certifying the notarial officer complied with the law. The notary may not affix a notary signature to or logically associated with the certificate until the notarial act is performed. So you've identified the signer. You've watched them sign the document. You've administered the oath or affirmation or acknowledgement that's required of that certificate, if it's required from that certificate. Then you can complete that. And you've made the entry in your journal also. Journal, right, for every notarial act. Then you can affix that seal to that record indicating that the notarial act has been completed. If it's a tangible record, the notary is going to affix their seal to that record with that certificate. It's going to be a part of or securely attached to the record. And so the certificate shall be part of or securely attached to the record. What does that mean? That means if there's no certificate, the notary needs to attach one to the record. How do you attach it? You could attach it in many ways. A few to think of: staple, clip, stamp, write, ink to paper. Any way that you can securely attach it to the record is satisfactory. If the notarial act is on an electronic record for the notarial officer may attach the official stamp or logically associated official stamp with the certificate. The certificate shall be affixed to or logically associated with that the electronic record. A few other things here about notarial certificates. It must meet the requirements of the law. It can be in a short form that's provided in 18-216 of the state government article of the annotated code. So the notary law, it's super nice. It actually gives you sample certificates for each type of notarial act that you can use to complete the notarial act. So folks often say, where do I get a certificate? It's right in the law. We have examples in our handbook as well. Or it must be in another form as allowed by law or applicable in the jurisdiction in which the notarial act was performed, or sets forth actions of notarial officer, and actions are sufficient to meet the requirements of the laws of the state. Does it have to be an exact match to what is in that law? No. It needs to contain the basic elements thereof, though, so that it is satisfactory. How do we do different types of notarial acts? Well, there's different types, right? We talked about earlier, we mentioned it briefly: acknowledgements, oath or affirmation, witness attest, certifying copies, certified tangible copy of electronic record, make a protest of a negotiable instrument. So what are we doing here? Types of notarial acts. The handbook breaks down each type of act. It actually explains the steps of each act, right? And the certificate that could go with that type of act. It's all in the handbook. A breakdown of how to perform each type of notarial act is included in the handbook. And regardless of what type of notarial act, a notary must always ensure personal appearance before the notary, identify the person requesting the notarial act, record the notarial act in the notary's journal, apply the notary stamping device, and complete the notarial certificate. To go back to these types of notarial acts real quick: take an acknowledgement of a record. I acknowledge, so basically something that indicates it constitutes the signer's act and deed. Verification of oath or affirmation: somebody swears to the truth of something or attests to the truth of something. Witness or attesting a signature: the notary watches you sign it, they notarize, confirming the fact that you signed it. Or attest: I signed it before I came to the notary. I show up to the notary, I get identified, the notary, I attest to the fact that I signed this, and the notary is able to satisfactorily identify me as the person that I say I am that completed that record. Certify or attest to a copy of a record. Not so much certifying it's a true copy of exactly what they say it is, but it's a true copy of a record that is in someone's possession. We're going to have a town hall not too long from now that talks about all these types of notarial acts and how to properly attach certificates. If you're interested in learning this in more detail, I encourage you to attend that. There is also one from last year that we have posted on the Notary page of our website that you can watch for much more information about this. We're not going to go through every step, but these are the types of notarial acts you can do. There's a whole hour-long town hall about that posted on our website, and we'll have another one here soon. So electronic notarizations. You can conduct electronic notarizations or use electronic or digital notary stamping device and signature to perform a notarial act. So if you're just doing an electronic notarization, it's on an electronic record. It still requires the notary to be in the physical presence of the signer to complete the act on the electronic record. E-notarization is just a replacement of the wedding signature and stamp or seal. Everything else is generally the same. The notary must maintain an entry and journal for electronic notarizations. So an electronic notarization, not to be confused with a remote notarial act, which we're going to talk about next. Electronic notarizations, the notary, and this is also true though, this page for remote notarizations, the notary's signature and stamp must comply with the X.509 standard adopted by the International Telecommunication Union or similar industry standard technology. The notary may not perform a notarial act with respect to an electronic record if the digital certificate is expired, revoked, or terminated, invalid, or incapable of authentication. Remote notarization, so remote notarial acts. What is a remote notarial act? It is an act performed by a notary using certain communication technology for a remotely located individual. So we're no longer in the same room. We're using communication technology. We're in two different places, but I can watch you sign a document and notarize it while I'm in this different place. So effective October 1st, 2020, remote notarial acts on electronic records became legal in Maryland. If the notaries meet certain criteria, the remote notarizations using technology primarily intended for video conferencing were not allowed at that time. So we have a list of authorized remote online notary vendors, RON vendors for short, posted on our website. Those are the approved technologies that can be used to remotely notarize an electronic record. Effective June 1st, 2022, remote notarial acts on tangible records became legal in Maryland. Under certain circumstances, the video conferencing technology may be used to perform remote notarial acts on tangible records. So electronic records require the specific RON vendor. The tangible records do not require that. You could use standard communication technology to do remote notarial acts on tangible records. We're going to talk about each of them here in a little more detail. When performing a remote notarial act, the notary public, the Maryland notary, is still required to be physically located in Maryland. So the signer could be wherever, but the notary is still standing in Maryland, even during a remote notarial act. Remote notarial act on electronic record, effective by law October 1st, 2020. Remote notarization, a signer appears before the notary at the time of the notarization using the audiovisual technology. The signer signs a document electronically. The notary notarizes the document electronically. This technology is allowing you to watch that person sign it in real time, and they can see you affix your seal and complete the notarial act in real time. This is all happening on the RON vendor technology. An electronic record must be done using that RON vendor technology. Regardless of the nomenclature, you'll see a couple different terms here. The remote notarization requires signing, witnessing, and notarization to occur during the same transaction. So the same transaction at the same time and place with us before each other using that RON vendor technology to do all this. This remote notarial act replaces, can be used to replace the in-person notarial act, right? Obviously, still traditional notarial acts done all the time, every day, everywhere. But you could use remote technology on an electronic record to perform a remote notarial act. And it's basically taking your traditional in-person experience and putting it all online in real time. It's an electronic record. I see you, you see me, we talk to each other, we can see and say to each other the whole time. I see the electronic record on the platform. I can see you affix your signature. You can see me affix the notarial certificate and seal, or complete the notarial certificate and seal, all at the same time, at the same place, at the same time on the same platform. No coming and going and stuff like that. The electronic record stuff, oftentimes the RON platforms are also, they require something called identity proofing and credential analysis. We'll have a town hall about remote notarial acts later this year. We had a town hall about remote notarial acts at the end of 2022. It is also posted on the main notary page of our website. And it's a whole town hall about this that talks about all the ins and outs of remote notarial acts in more detail. If you're interested, I encourage you to watch that town hall. Remote notarial acts on a tangible record. This is a little different. This became allowed on June 1st of 2022. It allows remotely located individuals signing a tangible or hard copy document using a wet signature to be remotely notarized. This is only allowed for individual that the notary can identify by personal knowledge or credible witness. If you don't know this person and cannot identify them through personal knowledge or credible witness, you cannot remotely notarize a tangible record. If I don't know you and I need to identify you using satisfactory identification, such as a government-issued photo ID, cannot remotely notarize a tangible record. Must personal knowledge of the identity of the signer or a credible witness. If the notary must identify I just said that. Need to use the RON vendor technology. If you don't know their identification, you need to identify them satisfactorily using the traditional identification method of driver's license, passport, non-driver ID. This type of notarial act causes a tangible record to be signed and notarized. The record must be tangible throughout the entire process. So we talked about remote notarizations used for an electronic record. It's an electronic record through and through, all in real time and happening. For a remote notarization of a tangible record, it has to stay a tangible record through and through. Well, how do I get that notarial act to be done if you're there and I'm here? Well, there's a process that plays out for that. But the notary would have to watch you sign the record using this communication technology. The notary is responsible for keeping that notarial act recording and maintaining the recording for 10 years. The nice thing about RON vendor technology is it keeps the recording for you, right? You're doing just a traditional communication technology. The notary is required to keep that recording for 10 years. There's a process, and again, the full town hall will explain the process for remote notarial acts on tangible records. Don't just run out there tomorrow and start remotely notarizing anything and anybody. There's a process that plays out. You have to actually provide us a notification form and complete a notification form in order to get authorized to remotely notarize, whether that's remote on electronic or tangible. Charges and fees. A notary public may demand and receive up to $6 for the performance of an original notarial act. This is the fee that's charged for each signature that the notary is notarizing. $6 for your traditional notarial act. If you are authorized to do remote notarial acts, you can charge up to $25 per remote notarial act. So $6 for your traditional notarial acts in person. If you're authorized to do remote, $25. You may not demand and receive more than those amounts. You cannot ask for more than $6 for the traditional notary act. You cannot ask for more than $25 for a remote notarial act. You cannot receive more. People will ask us all kinds of questions about fees. Well, can I charge a convenience fee? Nope. What if they want to tip me? Nope. What if it was really late in the night and I did it at 4 a.m.? Nope. Don't answer the phone at 4 a.m., right? So you cannot charge additional fees other than what is found here. No matter how creative you are with what you're trying to get someone to pay you, it is $6 for a notarial act for traditional, $25 for remote. You can also charge if you need to notarize, if you're traditional notarial act, so in-person traditional act on paper. If you notarize one thing, that's $6. If you're being asked to notarize the exact same thing twice, then it would be $3 for each signature thereafter. Notary, or each document thereafter, I should say. Notary may not demand and receive more than $2 to make a photocopy of a document that was notarized. The notary public may demand and receive reimbursement at the IRS rate for travel. So business travel, rate set by the IRS. You can charge a mileage fee up to that amount. You may also charge a fee not to exceed $5 if travel is required. So I'm going to break this down a little bit. You need to travel to do a remote, if you don't need to travel to do a remote notarial act, you can do that from anywhere in Maryland, but you need to travel to do a regular traditional notarial act in person on a tangible record, and you're going to travel. You can charge $5 because you're traveling somewhere. You can charge mileage for the amount of mileage it took you to travel for that remote notarial act, and $6 per notarial act on top of that. So if you're traveling, you can go $5 because you traveled, plus mileage, plus the $6 for each notarial act. So Kathy, I think I heard you say something. I think you're on mute at the moment. You're on mute. I don't hear you.
Yep, thank you. So just to clarify, you may charge $5 if you are traveling to perform a notarial act. There is no travel fee permitted if you're doing a remote notarial act.
Correct.
So you may charge a maximum of $5 if you're physically traveling to perform a notarial act, and the IRS business travel reimbursement rate.
Right. And those are in addition to the $6 per act.
Correct.
While you're there. Again, these are the fees you're allowed to charge. Does not matter how creative or what you can think of otherwise. These are what you can charge. There's no convenience fee. There's no service fee. There's no after hours fee. There's no I don't like you fee. There's none of that, right? This is what you can charge. You can charge up to this amount. People will ask us, do I have to charge it all? No, you don't have to charge anything if you don't want to. You can charge less than these amounts. You just cannot charge more than these amounts.
That's another really excellent point, Mike. Thanks for mentioning that. Because the truth is that when you're documenting your fees and the notarial act in your journal, it's really wise to actually document each and every fee that you're charging. It's amazing how many people will complain that they've been overcharged. So please make sure that you actually, if you have a travel fee, if you have an IRS mileage fee, if you made a photocopy, whatever it is that you're charging for, including the performance of an act, or if you didn't charge anything, indicate that. That may come back to really help provide you coverage later should you need it.
Exactly, and that's exactly great point. And that's when I mentioned earlier about making, noting the fee in your journal entry and providing a breakdown of what those fees are. That's exactly what I meant by that. So yep, break it down if you charge a fee or if you don't. Last item here on the top on the list of things, public information. Parts of a notary's record are public information under the public information laws. Name of the notary, business address of the notary, business phone of the notary, issue and expiration dates of the notary, the date the notary took the oath of office to become a notary, and the notary's signature. They are all public record. The home address is not, unless you do not maintain a current business address. The home phone is not public record unless you do not maintain a current business phone number. So the SOS may publish info relating to the status of the notary's commission, including date of commencement, expiration, or any note of any suspension or non-renewal or revocation. So we can note what the status of the commission is, but we don't provide further details, can't provide further details on the website than that. So if you're expired or revoked or suspended, we could put that status on there. We could provide your name, business address, business phone number, issue expiration commission dates. Again, though, the SOS may allow inspection of other information about a notary if the custodian finds a compelling public purpose, but that would only be provided upon request, and a compelling public purpose would have to be provided. If the notary does not maintain or have a current work address or work phone number, then that home address and home phone number are public information. We talked about keeping your stuff up to date earlier. Make sure you update your information. so that we have your current work address and work phone number. If we do not, then that home phone number and address would ultimately be public information. If you don't want that shared, make sure we have your current work info. So some upcoming town halls. We have a few here coming up throughout the rest of the year. I mentioned types of notarizations, allowable actions. That's going to talk about certificates and different types of acts in more detail coming up in May. And then some more town halls coming up in the fall of this year about different topics. And with that, Kathy, I'm going to turn it back to you.
Thanks, Mike. And Mike, thanks so much for a great presentation.
Thank you.
Just a reminder, a final reminder, that the content and presentation provided is for informational purposes only. It is not intended to be legal advice. And that the recording from today's town hall will be posted on the Office of the Secretary of State's Notary webpage. So please feel free to refer to it as often as you like. I'll also mention, if you want to find the link for the IRS, that's the Internal Revenue Service mileage, go to their site, the Internal Revenue Service, irs.gov, and you'll find that information there. They update that routinely, so please refer to them.